Welcome to Senate Energy and Natural Resources. In the absence of Kevin Avard, Senator Avard, I will be chairing today's hearings. I'd ask you to join me in the Pledge of Allegiance and ask Senator Gray, as a veteran, to lead us.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right, at this time, we'll open the hearing on House Bill 169, establishing a commission to study the removal of unused utility poles following the transition of equipment, lines, and cables to new utility poles. And recognize the prime sponsor, Representative Grote. And if he's not here, then perhaps...
Mr. Chairman, I'll be happy to introduce House Bill 169, establishing a commission to study removal of unused.
Turn your mic on.
Mr. Chairman, Senator Waters is before. I'll introduce House Bill 169, establishing a commission to study the removal of unused utility poles following the transition of equipment, lines, and cables to new utility poles. And I will note this is not a new issue before us.
Very well, you may introduce. So, signed up to speak to the bill, Representative Vos, would you care to give a little bit of background on this before we get into the meat of it?
Yes, Mr. Chairman, good morning, and thank you, Senator. It's good to see you all. Representative Michael Vos, Rockingham District 9, Chair of Science, Technology, and Energy. We heard this bill in early 2021. We retained it because we weren't sure that it was necessary to establish this commission. We had a subcommittee that did a working session on it and determined that it probably was a good idea, so we ended up passing this bill 21-0 out of committee, and I think it passed on the House consent calendar. Basically, this isn't a big problem or a widespread problem, but for the people that it affects, it's a big problem. So there are properties around the state where utility poles get installed, new utility poles get installed, and the old pole doesn't get removed. And it's an eyesore, and in some cases, it can be a bit of a hazard for property owners. So we decided to establish this study commission to look into this and decide to what degree this problem was significant and what should be done about it. So that's the gist of it.
All right, thank you very much. Any questions for Representative Vos? Thank you. All right. Natch Grayes from New Hampshire Municipal Association. All right, in support. Donna Gamache is in support, not speaking, from Eversource. And we have Josh Elliott speaking, neutral on the bill.
Good morning, Mr. Chairman, members of the committee. For the record, Josh Elliott from the New Hampshire Department of Energy. As you mentioned, we are neutral on the bill. The department has one request, and that is to be added as a member of this study commission. The duties of the commission, which are laid out in lines 27 through 30, make reference to the PUC 1300 rules. The department, as well as with the PUC, are in a lengthy process of sort of separating out and dividing rules as to who has jurisdiction over what. The department will be taking over some of the current PUC 1300 rules, including some of the specific ones mentioned here. So we thought it would be, if amenable to the committee as well as the prime sponsor, to add the commissioner of the Department of Energy or designee as one of the members.
Very well. Any questions for Josh? Hearing none, thank you very much.
Thank you.
And that completes the list. I take a motion to go to executive committee. Is there a second?
Second.
Okay. All in favor? Aye. Any opposed? We might as well discuss this and get it out of the way if we can. I don't see any need.
I guess, Mr. Chairman, I wanted to do an exec without the chair here.
Yes, I've spoken to Senator Abar. Yes. No, and I fully respect the question. I didn't share
Suggested to
that
some
information,
people
yeah.
that maybe we wouldn't be today, but
Yeah.
fine, I'm happy to move to pass on this. With, excuse me, let me move a committee amendment that would add
Number 7.
on, let's say line 24 as F, one member representing the Department of Energy.
Everyone on the committee okay with that? Senator Gray?
Weird.
Might I suggest we put in the commissioner or designee so that it makes it clear? Thank you.
All good with that as a committee amendment? All right, let's take a motion just to make that happen.
Yes, I'll move as a committee amendment, F, Commissioner of the Department of Energy or designee.
I'll second it, okay? Seconded by Gray. Further discussion? Hearing none, all in favor?
Aye.
Any opposed? That motion carries. I'll take ought to pass as amended motion by Senator Perkins Quokka,
The second.
seconded by Senator Waters. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? And the ayes have it. Consent? Right. That's committee amended, okay. Who wants to take it out? I'll take it out. All right, Senator Perkins Quokka, thank you. Sure. All right. All right. I know. One down and 1, 2, 3, 4, 5.
Move to come out of executive session.
All in favor? Any opposed? Okay. So another 2 minutes and we'll be into the next bill, which will be House Bill 410.
If you have any questions for the Department of Revenue, there is someone out in the hall who you have to come in. If you have any questions, but she is here.
Thank you. All right, it being 9:15, we'll open the hearing on House Bill 410, establishing a commission to study the assessing of power generation and utility transmission, and recognize the prime sponsor, Representative Murner. Welcome. It's been so long.
Good morning, Mr. Chairman and committee. For the record, Troy Murner from Lancaster, Co-op 7. I'm a floatarial. I cover 12 towns in the North Country. And the reason for filing this bill is goes back almost 4 years ago. We had House Bill 700 that was worked on intensively. She was not here at the time, but it was a long, drawn-out process for utility assessing, and there was a piece that was left out with the generation plants, which can be explained by the experts, that when Eversource sold all their generation, the companies that bought them, a lot of them did not file those taxes since 17. So we didn't get it into the other bill. So with there's two of us on the bill, myself and Pat O'Brami, who worked very hard on 700, and he worked with it so we wouldn't undo anything that was in the other bill. And that's where we are right now, that we've come to this and to address this problem.
Okay.
And it passed the committee, I think, 20-1.
Fierce opposition.
And I'm science and technology, so,
Right.
and a couple of other committees.
Okay. So, any questions for Representative Murner?
Okay.
Hearing none?
No, and I can have Patrick speak more clearly to what the nuts and bolts are. Thank
Sure.
you.
Representative Brahmi, speaking in support and as a sponsor as well, co-sponsor.
Thank you, Mr. Chair. Mr. Chair, for the record, State Rep. Pat Abrami, Rockingham, 19 Streatham. So this bill started out as just a study committee to look at how there was issues related to data being provided to assessors. So that's what that bill was originally. And that bill was retained and was being worked on last fall. In the meantime, I had the power generators approach me and said, Pat, you know, we have a real issue with the way power generation facilities are being assessed by the municipalities. And I've heard this before. So on other things, distribution and the telecoms as well. So I approached the Science and Tech Committee and said, it's my understanding that Senate Bill 410 is there. Can we amend that bill to broaden this out and make it a commission? And not just a study committee, but a commission represented by, obviously, legislators, but also by folks from the power generators, the municipalities, and the assessors. Now, some of you may remember, and I think Representative Murner mentioned this, several years ago in my committee on Ways and Means, we got a bill had to do with telecom assessing. And I was chair of the subcommittee on that one, and we beat that to death until we got a formula in statute that once and for all solved the problem of how do we assess a telephone pole and other assets related to that. I mean, those poles were assessed from $200 in one community to $2,000 in another. We fixed that problem. Then I was approached the next year by the distribution folks, the Unitels, the Liberties, the co-op, and that involved not just electricity, but it involved water and gas, and that pretty much was Liberty that had the other two. So we formed a commission this time, and we worked that very hard, as Representative Murner said. And the first meeting of that commission, I said, is there anyone in this room that doesn't think there's a problem to be solved? And everybody said, yes, there's a problem to be solved. I said, good. So I said, we're not going to be done with this commission until we come up with a formula, which we did. And it had to be simple, workable, and it did pass. So now I was approached by, and in that period, we decided not to deal with generation or FERC-regulated transmission. At the time, FERC-regulated transmission wasn't a big issue. Let me explain how that got into this bill. My original thought in amending was that we just look at generation. And then your desk, just for your, I have this document just so you know, for the record, there's 59 generating facilities in the state. 7 fossil, 1 nuclear, 37 hydro, 5 wind, 6 biomass, 2 methane, and 1 waste to energy. Now, some of these are small, very small. So when we look at this, we have to look at, how do we treat Seabrook as we do a small hydro that's only running when it's, the snow is melting, and we understand that. But anyway, I just want to give you a sense of getting our arms around this. So what happened is, since the original bill was to look at transmission, gathering information, the Science and Tech decided to add transmission onto this, which is fine, and we'll take a look at transmission as well on this. And I also handed this out just for your background information. This is just not transmission, but this is just the jet power generation. How each town now, different from the other two, different from telecom and distribution. Not every town has generation, and you can see here what the generation is, just at your leisure if you want to take a peek to see what that is. So I had met with the Department of Revenue on this. They described to me how they did their assessments. I guess the biggest concern, you'll hear from the industry here, the biggest concern they have is why are the DRA's assessments this, and what they see on the what is that called, well, let's just say the town's assessment is so much higher. So we want to get our hands around that and work that. So that's basically the bill, to form that commission, and we'll move forward with that. Yeah, I'll take questions.
All right, any questions for Representative Rami? Senator Perkins-Coulter.
Yeah. Thank you, Representative, for being here. So in thinking about a unified approach, as an example, would that be perhaps a recommended pilot rate that municipalities could use when they're assessing?
Well, we're not going to jump to a conclusion, but with for instance, with Seabrook in the mix, it may not be able to be a unified approach because they're so much different. Right now, what Seabrook does is they negotiate with the Seabrook power plant negotiates a tax rate with the community, with the Seabrook itself. And so what we're going to come up with, what I do know, since I met with the DRA, they do use a unified approach, their methodology. But we have to look at that methodology as part of the bill. It says to look at their methodology. And we're going to have assessing experts in the room, in the commission with us to help us with that. And then we'll see if there's some kind of a unified approach that we can apply to generation. I think actually transmission will be a little easier, but generation is going to be a little trickier. And it could be that there isn't a solution, but I think there is for categories of plants that we can come up with.
Follow up, yeah.
Representative, would you believe that in other states there have been unified approaches? So I think it's a good idea. And
well, I just didn't want to jump the gun. Actually, in the wording of the bill, one of the objectives of the commission is to survey other states to see how they approach this. So I'm with you on that. Thank you.
Thank you.
Any further questions? Hearing none? Thank
Thank
you very
you.
much, Pat. Okay, Nats Gray is not speaking, but in support. Kathy Fox, Great River Hydro, not speaking, but in support. And James Wheeler from Sanssouci Associates, speaking and in support. Welcome.
Thank you. Thanks for the opportunity to speak. My name's James Wheeler. I work for Sanssouci Associates, which is an assessing firm that does special property assessing, including these types of facilities that we're talking about, utility properties, generation facilities, transmission facilities, and distribution facilities. And I simply wanted to come with some very short testimony to express our support on behalf of our municipal clients. I'm really here for them today and express our support. I know the bill did start out originally as essentially a reporting bill, and very happy to see that has remained in the bill. We think that when you think about the assessing process, it's largely a mathematical process, and we've all heard the term garbage in, garbage out. There's times when my company cannot get the information it needs, and so it has to make assumptions to complete the assessing task. So again, glad that reporting is in there. Glad to see the expansions in the bill, and again, happy to support it.
Thank you for your testimony. Any questions from members of the committee? Hearing none, thank you.
Thank you.
Not speaking, but in support, Donna Gamache from Eversource. Not speaking, of course, Representative Vos, Rockingham 9, but in support. And Dan Dolan from the England Power Generators Association, speaking and in support.
Good morning, Senators. I'm Dan Dolan, President of the New England Power Generators Association, and appreciate the time on this bill. We are in support of House Bill 410, and appreciate the leadership from Representatives Murner and Abrami in bringing this issue forward. Our organization represents over 90% of the electric generating capacity across the 6 states of New England, including the vast majority of those facilities here in New Hampshire as well. I'm also here with my colleague, Molly Connors, who will be spending a little bit more time in front of this committee moving forward as well. With respect to this particular issue, we have started to see a widening of differences in valuations between municipal processes and in the state through DRA. Widening versus what we see in a number of other states, and what historically some of those deviations which sometimes occur here in the state as well. And so our hope is that in setting up the study commission, there's an opportunity to evaluate why that's happening, to the degree that there can be a more common approach that's taken across the board, and then come back to the legislature and see if more guidance might be necessary from the state on those processes overall, to hopefully then create less volatility in those valuation processes on a year-to-year basis, and then cut down the litigation risks that exist both for municipalities and certainly for the facilities we represent when there are disputes about those valuations. We take our role very seriously, certainly as some of the larger taxpayers in a lot of those communities, and so I hope that this presents itself as a thoughtful, deliberative approach to look objectively at all the various information that's necessary to come up with those valuations. So I'd be happy to answer any questions, but I appreciate the opportunity here and urge the committee to vote in support.
Any questions from members of the committee? Hearing none, thank you
Great.
very much.
Thank you.
Is there anyone here present that has not spoken or spoken once would like to speak again? All right, hearing none. At this time, we'll go ahead and close the hearing on House Bill 410. And we have 1 minute. No, Kevin wanted to hold it, yeah. All right, being 9:30, we'll open the hearing on House Bill 490, an act relative to definitions of game camera and hunting day and relative to the use of game cameras, and recognize the prime sponsor, Representative Roy.
Are we ready?
Not yet. Hang on
No.
just a sec. All right, can we pull that door closed, please?
Appears we have seating issues. Apparently.
We
More than I knew.
We hope. All right, Representative, go ahead and begin.
Good morning. My name is Terry Roy. I'm Rockingham 32 representative, representing the towns of Candia, Deerfield, Nottingham, and Northwood. I'm here to introduce HB 490 today. And I'm in the unenviable position of asking you to kill HB 490. This is a bill that I had drafted that would allow the use of game cameras. And somewhere along the committee process, it was changed to something totally different to require landowner permission to place a game camera. That position is contrary to our current land use for hunting purposes in New Hampshire. Over 70% of the land in New Hampshire is privately owned, and you do not require permission to hunt on landowner private property unless it's posted. You don't need it to put up a tree stand as long as it doesn't damage a tree. This would require to use a game camera, landowner written permission, which goes contrary to the rest of the entire hunting process in New Hampshire. It's my understanding there's an amendment that's going to be offered by another representative, the chair, and if you so choose to accept that amendment, then I would be amendable to it. Otherwise, I would ask you with all due respect to please kill it. It's not what we intended. It's not what I intended. It did pass the House on consent. And the
All right,
reason.
Representative, would you please close the door? Thank you. You may continue.
I'm sorry. It did pass the House on consent, and the reason for that is because we were under the understanding that the only thing that changed in the bill was the hours that the camera could be used. Shame on me for not going back and paying close attention to the amendment. Otherwise, I would have pulled it from consent. Having said that, we are where we are, and as I said, if you are amenable to the amendment that's forthcoming, that would be great. If not, with all respect, please kill the bill. And I'm open for any questions.
Any questions from members of the committee? So can you state clearly your objections to the bill in its current form before the Senate committee?
Absolutely. Currently, it would require written landowner permission to put up a game camera in the woods where you're hunting. The problem with that is right now, you can hunt on private property without permission of the landowner as long as it's not posted. You can put up a tree stand to hunt from without landowner permission as long as it doesn't damage the tree. So this would require you to notify a landowner not only that you're hunting there, but that you intend to put up a game camera, which would defeat the entire purpose of the open use land policy in New Hampshire. And it would cause a lot of problems that don't exist. In other words, people that own acreage, people are free to hunt on it, and landowners may or may not know, but this will bring to their attention, hey, I'm in the woods, I'm hunting on your property, and I'm putting up a camera, and now you need written permission. It could lead to all kinds of problems that aren't necessary. That would be my main objection.
In your opinion, is there a problem with the current law in its present form?
My intent with the bill was to address the present form is that currently you can't use a game camera that sends you a cell phone picture on the same day that you're hunting, under the premise that that wouldn't be fair chase. I intended to get rid of that for the simple reason that anyone who's ever hunted knows that when you get a picture on your phone, the deer is not going to hang out at your tree stand by the camera and wait for you all day. As soon as you get out of your vehicle and step in the woods, the first twig you break, they're gone. So it really doesn't make sense from a practical standpoint. I understand Fish and Game has some objections because the technology is evolving so fast that there are your ability to hook networks of cameras so that you can practically cover the entire woods at once So I feel like, having heard them, there may need some tweaking to it. It can't just be a blanket, okay. So, as I said, it would probably be best just to either kill it or accept the amendment. And I will work on in the future, looking at something. My intent was mostly for older hunters and disabled people to get out there and check their cameras in the woods. It's very difficult to go out daily or weekly to look at it, so the cell phone camera is really convenient. So I would probably bring forward a bill in the future that would allow it for disabled hunters. Otherwise, no.
Further questions? Hearing none, thank you very much, Representative.
Thank you.
So, let's see. Speaking for Senator Bradley, who is still in Florida, Grant Bossy is recognized.
Thank you, Mr. Chairman. And Dale, I think you have copies of the amendment. If you're ever wondering how hard Senator Bradley works here, it's taking about 5 of us to cover his bills today. Good morning, Mr. Chairman, members of the committee. This is a letter from Senator Bradley, who is delayed by inclement weather impacting his travel. And he wishes he could be here today. Good morning, Mr. Chair and members of the committee. I would like to thank Mr. Bossy for filling in for me today and presenting Amendment 0359S to HB 490 as proposed by Rick Estes, my constituent from Ossipee. Mr. Estes is a former conservation officer and very knowledgeable about these issues. He approached me about an amendment to HB 490 that would clarify the removal of temporary tree stands and ensuring private lands are treated the same as lands managed by Fish and Game. Amendment 0359S accomplishes that. Attached is my testimony in the amendment and a letter from Mr. Estes that offers further explanation. Additionally, Mr. Estes pointed out an oversight in Amendment 0359S. In this amendment, a new Section 5 creates the similar treatment Mr. Estes is seeking, but inadvertently eliminates existing sections of RSA 20736A. The sections eliminated are 5, 6, and 7. I would request that the committee insert an amendment into RSA 20736A and retain sections 5, 6, and 7. Thank you very much for your time and consideration of this amendment. Again, my thanks to Mr. Bossy for filling in for me today. Jeb Bradley, New Hampshire, District 3. I would defer any questions, if you have them, of Senator Bradley. I can get you an answer. I would also suggest that if, as the prime sponsor indicates, you don't want to keep the underlying bill, that you redraft this amendment as a replace all as opposed to an addition while making that numbering change to comply with the current law.
May we have a copy of Senator Bradley's letter so
Yes.
that we know exactly which statute he's referring to that the error was made?
Yes.
Thank you.
If I may, Mr. Chairman.
Please.
Yeah, thank you, Grant. And I think that you answered my first question about this, that if this is going to be replaced all, that's what Representative Roy thinks is okay.
That was my understanding from his testimony just now, that he did not object to using the bill as a vehicle for this amendment if you decide, as he requests, not to carry the underlying bill.
And would it be fair to say that this is the, yeah, if I may, thank you. Would it be fair to say this is the language that Senator Bradley and I worked out in response to the previous bill we had about tree stands?
I believe so.
Yeah, thank you.
Senator Gray.
I was just going to point out to the senator that we did just get a copy of that to the prime sponsor just now, so, of the amendment.
Any further questions? Hearing none.
Thank you very much, Senator.
Representative Tim Lang. Oh, Tim Lang. There you go.
Thank you, Senator. Thank you for taking my testimony. My name is Representative Tim Lang. I'm a three-term state representative in the House of Representatives. I currently serve as the chair of the House Fish and Game Committee, as well as serve on the Ways and Means Committee. I have before you House Bill 490, which was amended by my committee to deal with some issues that came up within the scope of the public hearing. Following the public hearing, there was significant debate and the vote, and the whole issue came around the written landowner permission. There was huge conflict around that idea. Originally, the committee's concept for doing this was around landowner privacy and making sure that landowners were aware, especially things that can stream real-time video pictures, the ability for the landowners to know that those type of cameras were on their land. However, again, after the hearing and after a significant amount of debate, I offered you an amendment, which is Representative Roy was talking about. It strikes Section 2 of the proposed bill, which starts on line 17 and runs through line 29 on the first page. And that is the whole written landowner permission. We'd like the bill to move forward with the 10-hour rule, and we'd like the bill to move forward with requiring people who place cameras to put their names and numbers and contact information on the cameras for any landowners. Currently, that's not a requirement. So it treats these more like tree stands. Originally, we used the concept of tree stands and tree stands that penetrate trees, which do require landowner permission. That's how we kind of geared this bill around. But I think the written permission has caused a significant amount of conflict and debate and probably needs a separate bill to have a conversation and a full-blown conversation about. So I'd ask you to please adopt my amendment, which strikes Section 2 and allows the rest of the bill to move forward as written. The issue around the 10 hours was strictly around the 24-hour or same day was if you had a picture at 2 o'clock in the morning, it would completely prohibit you from hunting that area for the entire day. So you couldn't go out there at 3 o'clock in the afternoon, even though you were 13 hours after the deer, you had a picture delivered to your phone, you still couldn't go hunt that area by the current rules and current law. It was a significant amount of negotiations. Originally, I had proposed a 6-hour, but some committee members wanted a complete ban, and 10 was where we ended up settling on, was a reasonable amount. So if you got one at 4 o'clock in the morning, you could still go hunt in the afternoon at 2 o'clock in the afternoon at the end of your workday if you wanted to catch the evening hunt. So that was the general conversation. I'm happy to take questions or comments on the bill.
Senator Waters?
Yes, thank you, Mr. Chairman, and thank you, Chairman. And so, got this, makes sense. Have you seen the Bradley tree stand amendment?
I just briefly read it. I haven't had a good chance to digest it. Again, I think it was a topic of conversation outside of what my committee spoke to, but let me read it real quick.
So if I may, Mr. Chairman.
Please.
So, yes to your amendment as far as I'm concerned, but then we'd like to add that.
So I'd leave this for Colonel Jordan to speak to. My understanding is this would already be allowed. That tree stands that don't penetrate trees can be placed on open land, unposted land without landowner permission. And so I'm not sure that this does anything that's needed. We have a provision, I think, and again, Colonel Jordan can probably speak to this better, but underneath the current tree stand law, I think that we have a requirement that they label it anyway, whether it's a temporary tree stand, a tree stand that they leave up on a regular basis. So I guess I'd leave the Colonel Jordan to answer, but I don't necessarily know that this is needed under current law.
All right, we'll ask him, but I mean, I think we were feeling some need to clarify.
Yeah.
Further questions? So,
Senator.
explain to me, or maybe the Colonel can, how do we enforce this 10-hour ban? That just seems wildly impractical.
This was an interesting conversation around Fish and Game and with Colonel Jordan. As a former law enforcement officer, the ability to get a search warrant is what you would need, right, to prove that a person got the picture and saw it before the hunting. While I agree it's an extremely high hurdle for Fish and Game to be able to meet and do, it's still a hurdle that can be met if they have evidence that's been supported, that they get in advance. So again, it's about the investigation that they do, and if they come across information that would allow them, that they feel that this law was violated, they would just get a search warrant and pull the phone records for that camera device as to when it sent it, and then on the receiving device where it was received at.
So This would be applicable to those cameras that transmit,
Correct.
would not be applicable to cameras that do not.
Correct. Again, it's upon viewing, right? So if you read the chapter, it talks about upon viewing, right? So 10 hours of remotely viewing any image or video, right? So again, these are mainly about the cameras that transmit, and and while I don't think it's justified at all, there's significant concern about couch hunters, right? That basically sit on a couch, wait for the pitcher to come in, and go run out to the woods and shoot the deer, right? And that was what
knows better, right?
I don't think that ever occurs. I don't think it's reasonable to even assume it occurs, but there were people that were concerned about that, and that's why the 10-hour rule was put on.
Thank you for your comments. Any further questions? Hearing none?
Thank you, Senator.
All right. All right. Rob Johnson from the Farm Bureau. Speaking in support.
Thank you, Mr. Chairman. Mr. Committee, for the record, Rob Johnson, representing the New Hampshire Farm Bureau Federation as the policy director.
Thank you.
No, thank you. Again, Rob Johnson, representing New Hampshire Farm Bureau Federation as the policy director. We are in support of the bill. I'm a little disappointed, I guess, right now we have a bill that passed the House, out of committee with a recommendation about to pass the House. Let me start from the beginning. On the House side, the bill was introduced for dealing with live action game cameras. We took no position on that. The request for landowner written permission was an amendment that we proposed. What we submitted was the main law, and we asked the committee to take a look at that, and that's what we support. And I have a copy of that for the committee so that you can take a look and see where they started from.
So, Rob, are you speaking in support of the bill as brought forth from the House to the Senate, or any of the
Section 2 of the bill that's brought forward is what we support. The landowner written permission. We're talking about surveillance devices on private property here. Our members, the people, the farmers that I speak with, the landowners I speak with, it's discerning to know that there are cameras on your property taking pictures of you that you don't know about. We're talking about people who support hunting, who hunt themselves, but we think there's a distinction. You're going to hear about, well, we're going to lose land and things like that. That it's an impediment to seek permission. That in other states now, well, this could evolve into where there's a requirement to seek landowner permission just to hunt. We don't support that. We're talking something different. We're talking surveillance devices, and I just want to be clear about that, surveillance devices. And think of your own home, that if somebody put a camera out in your backyard that you didn't know about. I've had this experience. I've been out in my wood lot, my back 40, chopping wood, working, to later find out there were cameras out there. And for a long time, I have two sons, and I've told them, guys, you see a game camera out there of any type, take it down. And we do. This landowner written permission requirement exists in the state of Maine, the state of Wisconsin, the state of North Dakota, in the state of Nevada that I'm aware of during the hunting season. And it may be in more states. That's just some of my research. Again, it's shocking in discerning that that there are cameras out there that are posted without someone speaking to the landowner. The technology, I think you're all aware, and everybody realizes, is evolving constantly with this. So there's more of an opportunity to survey, to keep track of whatever is on, the camera posters put out there. I'm trying to keep it brief here for you. I have a letter here I'll pass out to the committee. It's from a member in Representative Guidance District, a widow. Since her husband passed away a few years back, she now manages the family's 300 plus acres. And she wrote me a letter after seeing an article I had written in our publication and very supportive of the effort. And that was one of her contentions, and you'll see in her letter. She's a supporter of hunting. She welcomes hunters. But it's the surveillance devices placed on her property without her knowing where they're placed. I've got to tell you, like in my instance, and I'm sure it's as many others, it's not that we're not going to not allow the posting of a camera, but we're going to want to know where it's being posted and when it's there. We think this is a very reasonable requirement. And again, I'll say it again, everybody I speak with, and when I first learned, was shocked when we realized that landowner permission was not required. As far as the amendments you're receiving, I've seen in, one of the amendments anyway that would require a name and contact information on tree stands, and we think that should go further. Actually, our policy is to support written landowner permission for the putting up a tree stand. That's something that I spoke to the Fish and Game Commission a few years back. The current statute relative to tree stands allows them to be erected, providing there is basically no damage to the tree. Well, I have yet to see a tree stand that in some fashion hasn't damaged the tree, whether it's the spikes that are installed to get up, whether it's the hunters themselves that have trimmed trees so they've got an alley to shoot, things like that. And again, all this is not to restrict hunting. It's just so that we as the landowner know what is happening on our property. And again, these game cameras, I wish you keep in mind, they are surveillance devices. I know when I first brought this issue to my wife, she was shocked. She thought of other things that I had not thought of, as far as we have a young daughter, things like that. Again, keep in mind, these are surveillance devices. We strongly support the bill as it came to you, at least the Section 2 portion, and I'll leave it at that, and I'd be happy to answer questions. And I thank you for your time and attention.
Are there any questions? Senator Gray.
Correct me if I'm wrong, but the only remedy right now in law, if you are a landowner like the person that you cited here, would be to post the whole property as no trespassing. That way hunters could get permission to hunt on the land or other things, but they would have to post it no trespassing. Is that correct?
That's one way, Senator Gray. Fish and Game will, and has been from what they tell me for a long time, if you as a landowner find a game camera on your property, if you call them, they will remove it. But again, our position is that it shouldn't be there to begin with without landowner permission. The amendment, as came from the House, required that Fish and Game take it down because I know there was concerns with conflict, I believe, between a landowner and somebody who posted it. We have issues with that as well, but it wasn't something we had an issue enough that we would oppose it. We're comfortable with the bill as is, provided as that written landowner permission. I think what you could see is that landowners will post their land because somebody can put up a camera without their permission. I think is more apt to be an issue. I don't, excuse me, Senator, I just want to add one thing. I don't think, you may not realize the proliferation of the game cameras out there. At least on my property, 10, 12 years ago, there weren't any. And today they're numerous, let's put it that way.
Because the testimony has been that this wouldn't reduce the amount of land available for hunting, that's the reason why I asked the question, and I could see, get you to comment on, I could see that people would post their land, no trespassing, and that would, decrease the amount of land that was available. Comment on that?
I think it could result in that, where if I as a landowner don't have the ability beforehand to have written landowner permission, that I might just say, oh heck, I'm just going to post it, then I know, then I have that remedy. And again, that's not the intent. My family hunts, my boys hunt, my dad was a big hunter. I support hunters on my property. They're some of my best friends. Again, I'm talking We're talking surveillance devices here, and the technology is evolving, and I think it's a reasonable request for landowners to know beforehand, and they have that back. And if I know there's been, you'll probably hear some testimony about hunters having trouble finding out who owns the land, especially from an institutional investor, and they aren't getting a response from them. Well, if that's the case, then they're not going to care whether there's a game camera out there or not. We're talking about the people who want to know and where it's a concern for them.
Further questions? Thank you very much.
Thank you for your time.
Next up, Robert Clegg, representing himself, speaking in opposition. It's 80 in Tampa. All right. He's stuck because of the tornadoes. They got airplanes grounded all around the place. It's crazy. Colonel Jordan, if you wouldn't mind speaking next, I think you can shed a light on things here.
I don't know if I can clear anything up, but I certainly can. I'm very good at telling you my opinion, Senator. So thank you for having me. We had some issues with these cameras when they first came out. We were concerned. The agency was concerned. First of all, yes, let me back up. We are in opposition to this bill as it's currently written. The department is. The commission voted on that, and I'm very happy to tell you. There are pieces of it that the commission does like, but there are other pieces that we do not. And there's been some changes this morning that I know the commission would not support. So we are in opposition. We were concerned as the technology continues to advance. We, like many other states in the country, are looking at this very seriously because we feel that a lot of this technology is taking us away from fair chase principles. We're getting as far away from that as we possibly can, and we don't think that's in the best interest of our sportsmen and women. We don't think it's in the best interest of landowners, and it certainly isn't in the best interest of the sport of hunting. So we were concerned with live action cameras, drones, firearms that are being tested that can be fired without the person firing them. You know, we had a discussion, where do we draw this line? So we decided, the department decided to create an administrative rule that would basically not allow cameras. Our current rule reads that you can't use a live action camera, not the regular cameras, but a live action camera that sends a live picture to harvest game within the same calendar day that you saw that game on a camera. Now, most people, including myself, when we did this, I had some concerns about enforcement. I thought, you know, how this is going to be difficult to enforce. I also am an avid deer hunter. I've shot many bucks without the use of any cameras or bait. I harvest a decent buck every year, so I'm convinced it can be done with some hard work. And I was concerned about, I kept thinking about, well, a deer is not going to stand there after it's been on a camera. I'm here to tell you, folks, that is not the case. We make these cases quite often, a lot more often than I thought we ever would. Not that that's a bad thing, but don't think for a minute it doesn't happen, because I'm here to tell you it does. We just convicted 3 guys 2 days ago for this exact thing. So it does happen. So that calendar, we picked a calendar day because we felt it was easier for people to understand and easier to enforce. An hour, if you start breaking things down in an hour, I have to go to court and prove a much more finer detail on the time-wise, basically. The second concern that came, and so the bill when it originally came was to repeal that rule and to allow live-action game cameras to be used everywhere. We had real concerns about that because, again, that flies in the face of fair chase and completely upends what we're trying to. We're trying to convince people who are opposed to hunting that we're doing it correctly, that we're giving the species every ability to escape, that we're not using unfair advantages, and that we're doing it ethically. And this just doesn't help me with that argument. And so these cameras can be networked. You could lock down a 5 to 10 acre piece with a number of these cameras and literally hunt that piece and never leave your living room, because these photos will be coming back to you. So we had some concerns about that. The other thing that came up in the original testimony of this was the Farm Bureau, who I can tell you that New Hampshire Fish and Game has a great deal of respect for, because the majority of our land in this state is privately owned. And so when major landowners come to us and say, listen, we got a problem with this, And because of this, I've got landowners or constituents that are upset, and the remedy for that is exactly what you said. That now a landowner could put up a sign saying, I don't want hunting on my land, I don't want cameras on my land, I don't want people fishing in my pond. But my experience has been that they're gonna post it. They're gonna post it against hunting, and we're gonna lose open land, which is something in New Hampshire that we fight to keep. We hire people actually to try and maintain open land in our state. So when the Farm Bureau came to me with that concern, it got our attention, and then I thought about it as a landowner, and I got to tell you, it is absolutely fair for a landowner to say, I don't want someone on my property with a camera taking a live picture of me and sending it God knows where without my permission or my knowledge. I don't think that's an unreasonable request. I wouldn't want it on my land. I don't know where that picture's going. I don't know who that person is, and I think it's just courtesy to go to the landowner and ask permission to do that. Again, if the landowners, the major landowners in the state are asking for it, New Hampshire Fish and Game is going to be in support of that, because I think that's important to our mission. This amendment that Lieutenant Estes put in, retired Lieutenant Estes put in, came, so just so I can back up and clarify, currently, under current law, if you put a tree stand up or you build a blind that does damage to property, cutting tree limbs, does damage to a tree, you have to have written landowner permission and a permit for that. If you put up a climber or you're going to put up a ground blind, you're just going to assemble it on the ground, you're not going to do any damage to the property, you can do that without a permit. Lieutenant Estes was concerned. He brings to you a complaint that I hear from landowners a lot, and that is that people will go out and put up these blinds or these portable tree stands that don't require permits, and then they leave them up after the season is closed. He has some on his property, I know, that have been left up for a number of years. And so his amendment simply says that unless you have permission from the landowner, you must remove those tree stands by the end of the year. That's not a heavy lift for the sporting community. I still don't need a permit or written permission to put up a climbing tree stand if that amendment were to pass. If I was looking to leave it after, I think he put December 31st, if I was looking to leave it after that, I would be required to get landowner permission to do that. That to me seemed like a reasonable amendment. That came on after the House had voted on it and sent it over here. But again, I'll go back to my real concern, and that is, and the other thing that I want to make you aware of is it's quickly becoming one of the #1 complaints that we're receiving at headquarters, and that is landowners finding these cameras, calling into us to tell us that they don't want them there, and asking us, what are the rules and regulations regarding it, and then being quite surprised when they find out that people can do it. We don't let law enforcement do it. We make them get search warrants for the most part if they're doing it in curtilage. I don't know why we would expect to let everyone just post. I don't think it's an unreasonable request to ask for that permission.
Thank you. Questions? Senator.
Thank you, Colonel. I was reflecting that one of the first bills I introduced when I was in the Senate maybe 10 years ago was to prevent drones from being used to harass fishermen and hunters.
Right.
And we've come a long way.
We have.
Here, a whole new technology. So could you clarify, what's the status of the administrative rule now?
So the status of the administrative rule is it's in existence and in effect, and we use it all the time.
I'm sorry, clarify, what is
it? It's in effect, and we use it all the time, and it basically says that, I can read it to you, I have it, it's very, very brief, but it basically...
the site, that would be good.
Yeah, it's 31204, FIS 31204, it basically said no person shall use a live-action game camera to locate, surveil, for the purposes of attempting to locate for a fur-bearing animal for the purpose of taking or attempting to take during the open hunting season in the same calendar day that the picture is taken. That's basically what it is.
Another question, if I may follow up.
Certainly.
So, we have passed some legislation about the broadcast of images
Yes.
without people's permission.
Yes.
In another context, would you be able by rule to establish that any image that came from a game camera could not be broadcast, or would you need a statute to do that?
We could do it in rule. The statute has more authority, statutory authority, but we could do it in rule. And we did the live action camera in rule because we wanted to get it done quickly when they first developed. I also want to point out there are, I believe, 5 states in the country that completely outlawed the use of live action cameras during the open hunting season only. They allow it any other time. During the open hunting season, they don't allow it, and they did that due to pressure from landowners.
So if I may ask one more.
Yes, sir.
So we have, well, actually it might be 2, but we have, you know, a very small amendment which basically gets rid of this permission thing for now. And then we got the tree stand one, which you've already addressed.
Yes.
So, I mean, let's say we just basically make this go away for now. Would you want to have a study committee, or is this something you're going to be working on at Fish and Game regardless? And maybe bring some recommendation to the legislature next January for a new bill?
I will tell you the most important part of this, I think, is the fact that we have major landowners not happy with how we're doing it. I think that needs to be addressed.
Right.
I don't think this bill does that. In fact, I think it's taken a step today to further ignore it, and I don't think that's a good idea. I don't have a problem with the amendment, Senator, the Rick Estes amendment. I think it's pretty minor. It's just saying it's not creating any hardship for a hunter unless he looks to leave his stand up permanently. Then it just requires him to go get permission to do that. I can still put my climber up on my landowner's property, and as long as I get it out by the end of the year, if this were to pass, I'd be okay. The rest of that, I would like to oppose, and I would like to back up and take another step on that.
And just to clarify on the stand portion too, I think there was some, not exactly confusion, but what is also new here, from what I can tell from the existing statute, is putting a name on it.
Correct. That's correct.
Thank you.
And landowners are shocked, quite frankly, when they call in and find out that that's never been required, is putting a name up.
Good. Thank you, Colonel.
Thank you.
Seeing no additional questions, thank you very much. Kyle Baker.
Good morning. My name is Kyle Baker. I work with Rath Young and Pignatelli, and I'm here on behalf of the New Hampshire Wildlife Federation. The New Hampshire Wildlife Federation works to be the leading advocate for the protection of hunting, fishing, and trapping rights, as well as the protection and access to hunting, fishing, and trapping lands around New Hampshire. The New Hampshire Wildlife Federation is neutral on the bill. They have been neutral since the bill was introduced, as well as when it was amended. But we did want to raise a couple of technical concerns that some of our members had reached out about. Regarding cameras in general, we think there should be some sort of discussion around the differentiation between the traditional sort of store and review later cameras, as well as the sort of the live action cameras, just sort of because they have they look identical and they're very hard to just differentiate between, but the technology is very different. So we think they need to be treated a little bit differently. As well as we do have a little bit of concern around the hunting day language, just because the 10 hours period is a little bit confusing, and it could lead to a potential sort of conflict between sportsmen and fish and game conservation officers. And that's something that we definitely don't want to have. Another thing that's been talked about already is some of the concerns around sort of the institutional investment landowners that may be absent, no real concrete way to contact them. I can't tell you that it's a huge issue or there's a lot of them in New Hampshire, but we do have some concerns around it. And we think that even though those landowners may have no issue with placing the cameras on the property because they're simply holding the land as sort of an investment, the law would be the law. So we wouldn't want anyone to get unintentionally violate the law because they couldn't, even if they made a good faith effort to contact the landowner, we would have concerns with that. Regarding the amendment that was discussed this morning regarding tree stands, we would be in support of that. If you're placing an item on somebody's property, whether it's a game camera or a tree stand, you should put your contact information onto it. So whether it's the Fish and Game department that needs to contact you or the landowner itself has decided that they no longer want that item on their property, there should be a way to get in touch with you. And it also protects your own property. So if somebody were to take down your tree stand, particularly if it wasn't a landowner, say if it was another unscrupulous hunter that didn't want you in their particular area and they took down your tree stand, you may want your stand, permanently labeled so you would know it was yours. So we think that's a good change as well. So with that, won't take up any more of your time, but happy to answer any questions you might have.
Committee questions? Seeing none, thank you very much. Jason Parent. Welcome.
How are you? My name is Jason Parent, and when I was a state representative here, we worked on bills that preserved New Hampshire's heritage and allowed hunters to actively go onto unposted property. We secured things like attorney's fees for those that were unjustly accused of causing damage or had done something to somebody's property when it was unposted versus posted. So I'm well aware of New Hampshire's heritage in the hunting and so on and so forth. I am opposed as written to this bill in the aspect of a couple of different things. One, currently and most commonly, the New Hampshire Fish and Game Department is in charge of creating rules through the rules, JLCAR, that are imposed on hunters and sportsmen in the state. By making this into a law, I think first of all, what we're doing is we're going to make it very difficult if a few years down the road there's issues with that come up that are unforeseen, to be able to go back, as we know what it takes to get something put through the State House, to adjust a law versus adjusting a rule. So this is one of those circumstances where this type of thing, having somebody be required to put their name and their address on a game camera or on a tree stand, is something that can be done through the rules at the Fish and Game Department, and probably should stay with the commission and the individuals that are more at hand with what goes on in the state of New Hampshire. So that's a professional opinion. I own and operate Northern New England Outfitters, which is New Hampshire's largest hunting and fishing guide service here in the state. And certain things like this amendment to have somebody remove all their tree stands at the January 1st deadline, these are things that appear to be simple, and they appear to be, very easy for somebody to do. And in the circumstances of some people, that might be the case, where they have one area where they hunt, or they have one tree stand where they hunt. But in the effect of a small business that's operating in the state of New Hampshire, and we operate on mostly paper company land in the northern part of the state, where, kind of like New York State, we kind of should separate the state of New Hampshire for what happens in the southern part and what happens in the northern part based on land ownership and how it works. But in the northern part of the state, there's only a couple of major landowners. But one of those major landowners is the National Wildlife Refuge. And the amount of red tape and the amount of different hoops that you have to jump through to try and get something like written landowner permission is where it actually becomes a concern to do things like this. If you said, put your name on a game camera, put your address on a game camera, if a landowner from the Farm Bureau finds the camera and he wants to contact you directly and say, hey, we don't want this on our property, you've now been on notice from that individual landowner. Therefore, you would not be allowed to place a game camera on that property. In order to reach out to that person or to locate that person, like the Farm Bureau said, there's absentee landowners that are very difficult to get a hold of in the state of New Hampshire that own thousands and thousands of acres. Well, we can't just go put a camera there because we think that person wouldn't mind. It doesn't work that way. If the law is the law or the rule is the rule, we have to be held to that, and we're accountable for that. So that's one avenue of this circumstance. This is a practical aspect. This is what I do all year long, every day. So to put these kind of constraints or these kind of things onto people is going to be very difficult for them to be able in a 60-day time frame. So in other words, if you, as this bill states, we're going to go ahead and make these changes, and in 60 days, you're now going to be liable to get all these tree stands out of the woods that you might have in there, all these cameras that could potentially be without your name on them that are on private property, It's just not a fair, A, time frame to be able to do that in, and B, I think it's an unfair amount of constraints that you're putting on a group of individuals that was mentioned earlier. Now you start going to this landowner, and the 20 people that hunt on this person's property now go to that person to get written permission, and that person's like, well, that's a lot more people than I expected that were on my property. But yet some of those people were only maybe there for a day, or maybe there for 2 days out of the entire season. But each person would have to get landowner permission, even if you were going to put that camera out there for a day or 2 days or for a season. So now you've got a lot of requests going to individual people to get written landowner permission, which I think would be, people don't know, so they say that out of sight, out of mind. You stay out of people's sight, you stay out of their mind, therefore it's not an issue. But I think this would force a lot of people to bring it to the front of their minds and make them understand the amount of people that are on their property. And I think it would, in turn, definitely cause more posted property to be posted.
All right, thank you. Was there questions?
I have one more thing that I'd like to say, if you mind.
You've talked for a long time, sir.
Real quick.
I'll give you a minute.
Okay. One of the big areas of concern of this bill is the same areas of concern of the rule. And that is that if you read this, it defines things like area, same day, 10 hours, so on and so forth. There's no definition of what that means. In other words, if a deer were to walk by a trail camera at 6 o'clock in the morning, okay, is that deer now protected for the rest of the day, where nobody that has that camera up can now harvest that deer, whether he's a half a mile or 3/4 of a mile away? There's no definition of what area is, and there's no definition of, is it only that deer, or is there, if I go and sit in that area and that deer comes in with another deer, can I shoot the other deer that's not on camera that morning? There's a lot of things that go on with the way that this law and the way the rule is written that is very difficult to make any sense of. Okay, so that is a big problem with the way that this is written.
Time's up.
Okay?
Senator Waters, you had a question?
Yeah, thank you. Really kind of a clarification, because you know, on the tree stand issue,
yes,
that in 207-36A, it currently requires that you get written permission of the landowner to have a tree stand there. That is the current law. What this is doing is, in fact, I think, making things easier for you, because it says that you can get the permission to have it stay up there longer. But right now, you do have to get written permission to put up a tree stand.
Now, do you have to get written permission to put up a tree stand that does not harm the trees?
It says right here, 36A2, no person shall erect, build, see, that's a pit plan. So without damaging it, so that is,
Correct.
Anyways, I just think that there was some misstatement there about there is permission required.
There is not.
Now.
So
well,
currently to put
excuse me, 207-36A1 requires permission.
Does not. So you do not need permission to put a tree stand up on private land ownership if you do not damage or harm the tree in any way. In other words, you can't use screw in trees.
I'm sorry, we're talking at cross purposes.
Okay.
The point I'm trying to make is that if you have one that might damage a tree, you need permission, written possession. So that is in statute.
Correct.
This, anyway, so I don't need an answer to that.
All right,
but
is there
I just wanted
any
to correct
additional
that.
questions?
Thank you. No.
Okay, seeing none, thank you very much. Neil Pendleton.
Hello, thank you for listening to me today. My name is Neil Pendleton. I'm an avid hunter and a big user of game cameras of both types. This is my first time doing this, so please bear with me. I'm unfamiliar with this process, but I wanted to come today because why I'm really concerned and oppose this bill is this is something that wasn't made aware to us, because you'd have to get surmountable feat to try to think about getting that much written permission, not to mention the posted land that could occur, as Jason just brought up, to have to knock on that many doors and make people aware that they would need permission. It's like for something that was already, previously allowed, let alone hunting. It's like they may be like, well, wait a minute, you're allowed to hunt on this land without my permission as it is. So they become even further concerned. A lot is what's been talked about from people in support of this bill. They talk about the negative effects of game cameras. There's so many positive benefits of game cameras as it states right now. in the practice of better game management. We can be more selective as hunters in what we choose to harvest. We can educate people who aren't, typically hunters and show them the wildlife that's out there. One of my friends talked about he was almost ready to quit hunting before he was able to view the images from game cameras. There's a lot of sales that go into game cameras. I own 7 to 80 cameras. As I said, I'm a vast user of them. And in the 15 years that I've used game cameras, I can tell you there's probably only a handful of times I've had pictures of a landowner or someone that was unintended to get a picture of. So it rarely happens, and most of the time they're called game cameras because I am observing wildlife. They're not surveillance cameras. We are not trying to go ahead and get pictures of people. So I think that's been misrepresented as another thing. And then when it comes to even the certain current bill, which is, I just think it's gone way too far. It's gotten off the rails and it's so confusing in so many aspects, which is why I really think it should be killed, because there's certain language like received or viewed. Well, what does that mean? It's like when a picture is taken, if it's taken at 10 o'clock in the morning, but I don't receive that picture, because most of these cellular cameras aren't even live action game cameras. There's at least a 1 or 2 minute delay, even if I had that picture to be sent to me instantly. Most instances, people, to save their battery use, don't even get these pictures in states that allow them to be sent sooner than the same calendar day of New Hampshire, won't receive these pictures by choice 2 to 6 hours later. In New Hampshire, where I use these cameras, these pictures are going to be sent to me later in the day as it currently states. So the picture was taken, but yet if it changed, I wouldn't be able to hunt that animal till a certain time later on. So there's so much confusion there on, well, was it when the picture was taken? That's what I would think would make sense, not when I view the picture, because that picture could have been taken hours before I'm actually viewing it. And I hope I'm making sense with how I'm explaining that. I can think of all kinds of other great uses of game cameras. There was a woman that I bumped into. She had lost her dog. She had put signs all over town trying to locate that. Because I was able to move those cameras around, I wouldn't have been able to help her, go and do that. We're talking about hunting right now, but in the instances of just being, good neighbors, it's like we would be able to use these game cameras in so many other situations. I think of new hunter recruitment. There's a whole generation that technology, they're dependent on game cameras. It's like because they're so used to tablets, computers, and without the ability to be able to show them some type of video or image, we're going to lose, it's like new hunters. A story 2 weeks ago about a boy named Thomas that I met at the Moore Sporting Goods open house. I had sheds of a nice buck that I handed him the sheds. He held those, and he was talking about how his dad had a picture from a game camera of a similar looking buck. I showed him a game camera picture of that exact deer. He made the correlation as a young kid. This deer's still out there walking around. These antlers he was holding came from that deer. Well, 2 weeks later, at this last Saturday at the Trinity Baptist Church, I saw that same kid. His dad's telling me he was barely able to sleep for the last 2 weeks because he was so excited to tell me he had come up with a name for that animal. These are the things you don't hear about, all these positives of game cameras. There's always concerns with negatives, but I could go on and tell you all these great circumstances and all these great stories, how game cameras help stuff. Not to mention that, as I previously said, in the southern part of the state, game management is needed. They're allowing crossbows to come into only zone M and L because they need help with game management. Game cameras are a proven tool to do that, and by requiring written permission, it is going to restrict the use of game cameras to the point where it is almost impossible. So this is essentially an outright ban, in my opinion, on game cameras. I want to try to make sure we get this right as sportsmen. I don't see this current bill and also introducing it into law as the right way to do it. There's rules and regulations that can be made and updated through certain committees at Fish and Game. That would be my hope, that this bill is just stopped dead in its tracks and we can go back to try to figure out certain privacy concerns, because there is other ways that we can address those concerns of landowners. There's certain things about setbacks that currently exist for discharging of firearms. Well, if we discuss these certain things, we can come up with the way, to go and enact certain privacy things that I think would alleviate a lot of those concerns. And thank you for hearing me. And if there's any questions or anything that I can do.
Committee members? Thank you very much.
All right, thank you for hearing me today.
Michael, Matt?
Good morning. I only own a few cameras, but Jason and Neil brought up quite a good valid points of. Mike Gilmet, sorry, from Hooksett, New Hampshire. They brought up a couple good points with having cameras. I have a few cameras that I have, and I They're not cell cameras, but I still have to go out physically and move them because I only have a few. So they could be going on to 2 or 3 or 4 properties, which some of those properties, the owners, one of them used to be in Wisconsin. They're out of state. That would create some problems with me trying to hunt onto these properties. And another good point is that some of the properties I hunt, people pass through there hunting. They're not there. They may be there for 1 day, maybe 2 days, and they're not there again. So I think this creates a problem for a lot of these landowners that they're going to be bombarded with requests to hunt their property, but some of these hunters are only there for a day or 2 out of the whole season. To me, it's a hobby, and there's also a growing number of people that are non-hunters that are using cameras to monitor game on public land or private land. So these people don't even probably know about this bill. I post a lot of my videos to a lot of different sites, on Facebook sites and and you wouldn't believe the amount of people that are doing this. But to me, I oppose this bill. I think it's, I just don't see the point of it. I have a good working relationship with 2 big landowners that know me, and one of them, he was a forester. He's built his house and property on his land, and I met him, and I asked him permission. You know, I says my cameras are way out of his wherever he's moving on his property. My cameras are not going to be anywhere near him, but him and his wife had told me last year that they were happy that I was actually hunting their property and had a camera on their property because it kind of can monitor and they can see the game. I can send them videos of that. And I also think on the sites that I'm on, it's very educational for other people to see the game animals in a natural state. And that's pretty much what I like to do. It's a hobby for me as well as I'm a hunter, but I have never shot a deer and had it on camera.
All right, then
So-
we'll see if the senators have any questions. Questions? Seeing none, thank you very
Sir,
much.
thank you very much.
Patrick Rivard. Well, you can go get him, but while we're waiting, we got Jake Trickett. Okay. All right, tell them that Jake is next. Tell them that Jake is next. He's supposedly out there too. Jake, it looks like Trickett. Introduce yourself and.
Good afternoon, ladies and gentlemen. My name is Patrick Rivard. I am a hunter, attorney, and resident of the state of New Hampshire, and I am here to discuss the HB 490 regarding the use of cameras. Before I say anything, I just wanted to ask for some clarification. I understand that the chair of the committee has asked that the portion regarding written landowner permission, he's requested that that portion be removed. Is that correct?
There's several amendments that are being presented to us. They're available or will be available through the clerk. So
okay, I was following on the live feed, so I was trying to make sure that I was up to date. I don't want to beleaguer the point. The 2 things that I wanted to mention were that
he's opposed.
Oh, I'm sorry. I am opposed to the bill, at least as it is currently written. Thank you very much. First and foremost, I found it sort of alarming that I am fairly politically active in the state of New Hampshire, and I'm an advocate for the hunting community regularly, and yet I only found out about this bill as it's currently written yesterday. I did not have the usual time I have to make phone calls and get some of the people I like to get involved in these things online, and I felt a little alarmed that people were willing to support this bill when even the language...
If we don't have to worry about the Senate process, we need to hear what you think about the bill because you are here, please, sir.
Okay.
You can come to me and talk about process after.
Okay, thank you, Senator. That being said, I think that the burden that this puts on hunters, especially in the southern New Hampshire area with very limited time to hunt, is over the top I think that I understand there are issues with landowners wanting to know who is placing recording devices on their property, and that is a fair assessment. However, usually, in the rulemaking side of these things, we don't know what impact this is going to have on public land, because some people are going to be either too shy or have too much difficulty and not have enough time to go seeking the landowner permissions for these cameras. Many people rely on them now. It is a common practice with probably 60% of hunters in the state, probably more. And we don't know how this is going to push people into other areas, how it's going to affect the animals in those areas, the hunting opportunity in those areas. And currently, our public lands are already overtaxed by use with the advent of COVID and the amount of people working from home. I asked this committee to spend some time doing some research and finding out what impact this law, especially the written landowner permission section, will have on land use, on animal movements, and on hunters' pressure in certain vulnerable areas, and not rush into anything with a recently rewritten amendment.
Okay, so questions from senators? Seeing none, thank you very much.
Thank you.
And Jake is next. Jason Stock, you'll be right after. After Jake. Welcome, Jake.
Thank you. Okay. So from my understanding and how
state your name.
Oh, I'm sorry. My name's Jake Trickett, and I'm a New Hampshire resident. I live in Merrimack, and I'm a hunter and mostly bow hunting, but I use trail cameras to basically help me and assist me in during the season. And I'm not going to sit here and try to fabricate any truth from that. And I think I was just talking with some some hunters out there, and we need to do a better job, as hunters and represent ourselves better as to private landowners. And I'm obviously opposing this bill, but at the same time, I can understand from both perspectives. I can understand the private landowner and trail cameras to me are a small part of hunting. It's you still have to utilize where you put them and understand where you put them, and you still have to do a lot of scouting. And I can't be in the woods 24/7. I mean, I work a job, 40 plus hours a week. I have a kid here at home, a wife. I have a social life. So it's not the old times anymore. And a part of me has mixed feelings about that, but a part of me is excited for the future too. I understand you guys aren't trying to take cameras away. I'm not saying that, but that's my fear, is that if this bill does get passed, that's going to be the ultimate thing, and it's going to hurt the hunting community. I respect private land owners, and if they post land, obviously that's something we have to respect, and we should talk to more private land owners. But there's a lot of land out there that's privately owned that, logging companies or LLCs or corporations or even residents that own it that don't live here. And I've tried to contact an 80-acre parcel, and the guy lives in Florida. Like, I don't know how else to get permission. So now I just can't, I'm going to go basically waste a lot of time, or my one day I get to go out during my hunting season and take away from that time from my family or other things. Or I could put a camera there or a couple cameras there and try to really utilize that time. Cameras tell us a lot. Cameras aren't just, you see a deer or a turkey or a game animal and go after that animal. That it tells us a lot of things. It shows us how they communicate, how they act, where they feed, where they bed, age structure. It tells us, if it's a healthy herd or if there's good offspring. So cameras are a huge, huge tool for us. And so again, I oppose the bill, and that's basically all I really have to say.
Thank you. Good questions from senators? Senator Goddard.
Thank you, Mr. Chairman. If we were to require some sort of a flag on a wire pole or something, or coloration, orange coloration on the camera itself, so that a landowner would know there was a camera there, okay, would that be something that would interfere with the hunt? or the sport?
Sure, yeah, absolutely. I mean, you gotta, I think of it as when you put a camera in, you're putting something in the woods that already is kind of a foreign object, and a flag is just gonna stick out, and especially on a windy day, that's something we have to pay attention to. And there's basically, not to get into it, but there's 6-foot straps they give you so you can get around any type of tree. And I tuck my straps into itself so it doesn't blow in the wind. And then color is a huge thing. Turkeys, are, as we see in the springtime, which is coming up here soon, they turn different colors for reasons because they can see color. I understand that deer don't see that as well, but any color would kind of give that away. And I'm all for, I've heard people mention maybe putting in names or contact information on the camera. I'm all for that. I think that whoever finds our camera, I want them to contact me. And again, to sell cameras, that's an instant thing for me. If I see someone walking in front of my camera, now I know someone's there, and I'm probably not going to use that area. Or if I have a landowner put their name or like, hey, call me type of thing, I'm going to contact them. That's just my personality. Now I'm speaking for myself. So yes, to answer your question, I think it would interfere with hunting a lot, especially spray paint or any type of coloration because of scent too.
Okay, additional questions? Seeing none, thank you very much. Jason Stock.
Thank you.
Good morning. For the record, my name is Jason Stock. I'm the Executive Director of the New Hampshire Timberland Owners Association. And we do support the bill, and it's a little more nuanced than that, so I'll explain. But we do support the bill. And, our members own timberland across the state. They own and manage it. And they range from small tree farmers in the southern part of the state to large institutional owners in the northern part of the state and everything in between. And so, this issue has come up. I've vetted it with my internal policy committees and reviewed it and gotten a lot of different perspectives on it. I wanted to share that with you, and to the extent that it could help inform you and not further complicate your life, I'll provide that with you. I think the thing we want to first emphasize is that private land is just that. It's private property. And if you're hunting on private property, you are a guest. If you're placing a camera, a tree stand on private property, someone else's property, you are a guest. And I think that's an important thing to keep in mind when we review this and we look at it. And as a guest, and as a landowner, we believe you should be afforded certain courtesies and respect for it. And I would say 99% of the hunters out there and bird watchers and others do respect private property, and they are courteous. And so, once again, we find ourselves in the position of crafting policy for that 1%. And so that's something that when we reviewed this, that was part of our discussion. Clearly, the name and contact information on whether it's a tree stand that harms or doesn't harm a tree or a camera, we believe the name and contact information should be on it. I don't know how many logger and forester offices I go to where they're doing timber sales, and they have a garage or a storage room that's full of tree stands. And they say, I go out there, I cruise the timber, I mark the wood, I lay it out, there's tree stands out there, I'll leave my card on it, and I never hear from it. And I don't want to destroy it, but if I don't know who to contact, what do I do? And so we think that's just kind of common sense. And I think the prior speaker touched on that. Clearly that name and contact information, tree stand and a camera, whether it's live action or still camera, that should be required. And we would say put that in statute, not rules. We think it's important enough that it should sit in statute and not in rules. Permission, we believe that as a courtesy, hunters should be talking to that landowner, and they should make an effort. And to this notion that institutional owners or out-of-state owners are difficult to find or contact, I always say the tax bills find them, And if the tax bills can find them, certainly you can find them. If it's a large institutional owner, they have land managers. And they have land managers usually locally based. And those managers, particularly if it's a owner that does a lot of management, they're filing intent to cuts, tax records at the town. You can get names and contact information right off of that. This is all publicly available. So I think contacting landowners is just a good common courtesy. The written permission, I'll be honest, our policy was, or our committee was a little split on that. Again, we have some members particularly, and I think this is where we see a split in the state. We have members that are smaller ownerships that say, heck yeah, there ought to be some type of permission required, whether it's written or verbal. But we have other owners, and I think you heard some testimony today that say, look, I'm managing 80,000 acres. I have 4 foresters out there. I don't need them fielding dozens and dozens and dozens of calls requiring permission. And so, so in the bill, there was a kind of a safety valve for that, where if the landowner was okay with and this was a compromise, we agreed to, that if you're okay with cameras, you can put a sign up. Cameras, we're fine with cameras, don't bother us. We're trying to lay out timber sales, we're trying to cut some wood. I have not seen Senator Bradley's proposed amendment. I did see an earlier version of an amendment from Senator Waters that was, well, thank you. It's the same? Okay. And we support that. Again, quite honestly, like Senator Waters, we were kind of surprised. We thought, I'll be quick, we thought that name and contact info should be on the stand already, and this, I think, clarifies that. And with that, I will conclude my testimony. I certainly hope that something good can come out of this bill. I think there's enough here worth salvaging as opposed to just ITL and throw it on the ITL pile. We think there are some really good pieces in here. Maybe there's some elements that need to be talked about further, but there are some pieces in this that we believe certainly should be moved forward. Don't just kill the bill, and hopefully the folks in the House would agree with that.
Questions from senators? Seeing none, thank you very
Thank
much.
you.
Susan Price.
Thank you, Senators. I'm Susan Price. I am the Carroll County Fish and Game Commissioner. I'm also on the Legislative Committee at the Commission. As it's written as the current bill that came from the House, the Commission opposes for all the reasons that Colonel Jordan explained. We are scheduled for a Legislative Committee meeting next Tuesday, at 9 a.m. And the committee, we will fully discuss this. We'll have all the amendments. We will have a full committee meeting later that day at 1 o'clock, in which we'll have further discussion and hopefully be able to present the committee with a position from the Fish and Game Commission. But at this time, we do oppose the bill. I personally, I'm going to take should I take my thing off? I will testify as a deer hunter. I have one game cam on our property. The deer I took this year never appeared on my cam. I shot my deer because I had everything working in my favor that morning. It was within 6 or 7 minutes of first light when they're most active. It was the rut when they're all like teenage boys running around, not paying attention, and the wind was in my favor, and I was very quiet. I come from a family of deer hunters well before cams, and we had plenty of deer meat for dinner without the utilization of a camera that never even existed when I was a kid. So I have personal feelings that if you're a successful hunter, I can walk through my land, I can know when a deer's been there, I can know basically about how many. I think if you're a good hunter, you don't really need a cam to be successful. That's my personal experience. That's my family experience. Thank you very much.
Questions from the senators? Senator Waters.
Just to say, good to see you, Commissioner.
Yes, my old seatmate in the
My
House.
former seatmate in the House.
That's right.
Yeah. And I'm awfully glad you're on the commission.
Thank you. Appreciate it.
Seeing no other questions, thank you very much. Anyone else testify? And I'll hand the gavel back to the vice chair. So,
Hearing none, we'll close the hearing on House Bill 490. And we will immediately open the hearing on House Bill 543, establishing a commission to study nuclear power and nuclear reactor technology in New Hampshire. And recognize the prime sponsor. Is Representative Ammon here? No, then we'll expect Representative Vos, if you wouldn't mind pinch hitting.
Thank you, Mr. Chairman. Representative Michael Vose, Rockingham District 9, here to introduce House Bill 543, which is an act establishing a commission to study nuclear power and nuclear reactor technology in New Hampshire. We passed this law, or this bill, I should say, in an effort to put together a group that could determine if there is anything that the state of New Hampshire can do to try to advance the cause of nuclear energy within the state. Now, we all know that nuclear power plants come under the Nuclear Regulatory Commission, which is a federal agency. But the question continually rises, well, is there anything we can do at the state level to advance the cause of developing more nuclear-related energy technologies? And after thinking about it, listening to testimony, we decided that there probably are some things that the state can do. And so we set up this study commission to look into that. And as you'll note on page 2 of the bill, lines 4 through 30, we've identified quite a list of things that the commission can look at in order to determine if there's anything our state can do to advance nuclear technology. And not all of these are directly related to the generation of electricity. For example, we think it might be worthwhile for the state to investigate whether nuclear-powered desalination is something that state law could help engender. In addition, we heard during testimony before our committee that there is a $45 to $50 billion fund at the federal level that was created by collecting fees for the on-site storage of nuclear waste at nuclear power plants. And that fund can be used, according to the federal law, to promote and to build nuclear facilities, particularly if they relate to nuclear storage. So it's possible that New Hampshire, for example, could agree to accept nuclear waste from other states and store it on site at Seabrook, which has a nuclear storage area set up already. And by accepting that money or accepting that waste, we could be eligible for grants from the federal government from that $45 to $50 billion fund to set up research facilities to study ways to promulgate nuclear-powered technologies. So once we learned all that, we decided there was quite a bit that this commission could work on. It's not going to bring any nuclear power plants to New Hampshire, probably, although there is the possibility that small nuclear reactors might be appealing to utilities and industries that want to bring them here at some future date. Would require federal approval, but nevertheless, we thought it important to look at these technologies because in our judgment, it looks like both fossil fuels and renewable technologies will not together be able to satisfy our energy needs going forward. And nuclear technology will be able to fill that gap. So that's the substance of the bill. It has the usual study commission aspects. The list of people who will be on the commission are listed in the bill, et cetera, et cetera. The bill has a sunset. The commission has a sunset date. So it's all the standard stuff. Now, I know that Senate President and the House Speaker are trying to discourage the creation of committees and commissions because we already have so many. And it's becoming increasingly difficult to find senators and representatives to serve on these commissions. Nevertheless, we feel that this is an important commission that should go forward. And with that, I'd be happy to take questions.
Questions from members of the committee. Senator Waters.
Yeah, thank you. Yeah, I think it's very interesting technology, the Generation 4s, and, you know, who knows, right? Just a couple of things. On line 11 on page 2, the molten salt reactor, which I actually took a look at, could I assume that you would also take a look at the use of molten salt as energy storage?
I'm sure that the commission would look into that, yes, absolutely.
I think that there's a real potential there if we're onshoring offshore wind power, that the molten storage is potentially a way to go with energy storage from that source. And just as an observation too, I just was trying to remember how long ago it was that when the federal government had that commission, it was looking at potential sites for waste storage. Were you in the state when those commission meetings occurred, when they came around the state and toured? It was an interest. It was maybe 25, 30 years ago now, but it was, shall we say, interesting. And I visited Seabrook, and I see the platform they have, and well of sea level for the storage, and it's the dry cask, and it's all good, But I just was going to say the potential of our having more waste and storage here. It would take me back to those hearings.
Exactly.
Yeah.
Understood.
So we'll see. But good bill. Thank you.
Further questions?
Thank you.
Hearing none. Thank you very much,
Thank you
Representative.
very much.
Representative Thomas.
Good morning, Senators. I'm Representative Doug Thomas. I represent the Londonderry, Rockingham District 5. I also am the Vice Chair of the Science, Technology, and Energy Committee. And I support this bill, particularly the previous speaker is right on with all of the things that we could be looking at. But I'd like to point out one thing right now, and that is I believe this bill would do something additional, and that is it's time that we have a conversation about the new nuclear energy that will get rid of the old Hollywood movies of fear and destruction of what the old nuclear could have been. Hasn't been that way, but certainly we are farther along now than we were back in the 1960s. And as a member of your committee here stated, we recently had a tour of Seabrook Power Plant, which is the best run nuclear power plant in the country, and they have an exemplary safety record. I will say that I had recently served on the NCSL Energy Task Force, where I learned that small-scale modular nuclear energy is so far advanced that even the Air Force has contracted to build one up in Alaska. So I believe a commission like this would bring forth much opportunity about what might be available, not, I'm sure, in the next couple of years, but I think it will open up the conversation of what just might be possible here in New Hampshire. Also, to bring forth to the general public, to further educate them that not only is small-scale nuclear a very powerful tool that we can use for our energy. We all know that nuclear energy produces zero carbon emissions, but in addition, small-scale nuclear also produces, in terms of relativeness to, say, Seabrook plant, produces micro-sized small nuclear waste, much, much less than the current nuclear reactors produce. So there are advantages out there, and I think we need to discuss this. This commission will do that, and I'm totally behind it. And I believe that the rest of the other states, from my experience on the task force, are looking at it as well. And I think this is something that could be used in the mix, because not any one form is a panacea. I think we have to have a balanced approach to all of our energy needs here in the state. With that, I conclude my testimony, and I hope that you agree that this commission, although we have many of them, is one of the ones that could bring forth some very valuable information. Thank you.
Any questions? Senator Waters.
Yes.
With a question.
Yes, I do have a question. Would you believe that
Yes.
I am just extraordinarily delighted to see lines 1 and 2 on page 1, which read, purpose statement, eliminating carbon emissions from electricity generation is an urgent goal to mitigate the threat of climate change. Right on, brother.
We would,
Thank you.
and in the interest of time, we would cease.
I would agree you said that. Yes, sir.
All right, any further questions? Hearing none, thank you very much, Representative. Finally, speaking neutral, Josh Elliott from the Department of Energy. Josh is noted for his brevity.
Good morning, Mr. Chairman, members of the committee. I could almost just say copy and paste from my last testimony of the bill earlier today. The Department of Energy would respectfully request, if amenable to the prime sponsor as well as this committee, to add as an additional member of this commission, the Commissioner of the Department of Energy or designee. I'll conclude my testimony.
Any questions for Josh? Hearing none, thanks very much.
Thank you.
All right, that concludes. Is anyone here who hasn't spoken would like to speak, or who has spoken would like to speak a second time? Hearing none, we'll close the hearing on House Bill 543. Is there any interest in executing this now, or do you want to keep moving? He's okay. Yeah. Yeah. Okay. Okay. Waters moves, and Perkins Quokka seconds. The exec, all in favor signify by saying aye. Aye. Any opposed? All right. Is there a motion on 543 with the committee?
First, did I hear Senator Waters, say that he would love to be on this commission?
No.
Is that what I heard?
I visited
Just checking.
Is that a glowing recommendation?
Just checking. I thought I heard him say.
I'd like to move a committee amendment on page 2, insert after line 1, J, the Commissioner of the Department of Energy or designee.
He moves the amendment. Senator Perkins Quokka seconds. Any discussion? All in favor say aye. Aye. Any opposed? All right. Second by Gray. And any further discussion? Hearing none, all in favor signify by saying aye. Aye. Any opposed? Motion carries. Move to come out of exec? Who's going to carry it out? All right, Senator Waters. I'm sure you'll give a glowing account. All in favor? Aye. Any opposed? Okay, we're out of exec. This will close the hearing. We've already done that. So let's go open the hearing on House Bill 1005. And that's a bill relative to the creation of New Hampshire Low-Grade Timber and Wood Emerging Market Commission. I recognize the prime sponsor, Representative Thomas. Please.
Good morning, Senators. Again, I am Representative Doug Thomas, representing Londonderry, Rockingham District 5. And contrary to what might be looking here, I am not the bearer of all commissions today, but it just happened to fall in the same line here. 1005 is a much needed commission, which I am happy to introduce. And as a member of the Science, Technology, and Energy Committee, we see many bills come through that try to help out the electrical energy portion of our state here. But this commission is designed to see what else our forest industry can get involved with other than producing electricity. As you know, we have a few plants that do produce needed electricity, but that field is tough to compete. It has ups and downs, and we know there are other products out there that can help our forestry industries not only survive but thrive, and helps out our forests at the same time. So if I may, I'd just like to read a short introduction here where I say that many of you remember past energy debates about biomass energy. Biomass energy is a base load renewable energy that has not only produced electricity, but from a resource perspective has been an integral contributor to the management of the state's forests and lands because it uses low-grade wood for fuel. Unfortunately, the cost of biomass energy in times when natural gas prices are low can be much higher because of the cost of wood fuel, raising concerns about its ability to compete in the energy markets without additional program financial supports, i.e. subsidies. These policies have led to the closure or intermittent operation of 6 out of the 8 biomass plants that have been operating in the state. With the lack of operation, the forestry and timber industries have suffered for lack of outlets to address their low-grade wood waste. This commission is designed to bring experts from around the state and different facets of the timber industry to study and set forth any needed policies that can help emerging markets for low-grade wood. This would assist the industry on getting back on its feet and, more importantly, continue to protect and manage our forests and for many years to come. New Hampshire is the second most forested state in the country behind Maine, and the management of our forests is critical to New Hampshire's economy. I would also ask this committee to direct their attention to paragraph 1 of the bill, which I will not read, but it very clearly outlines the best interests of the state for why we should have this commission. I won't go into that, but it's extremely good paragraph to read. I'd like to conclude by saying that although I represent Londonderry, I grew up in the town of Orford, New Hampshire, and I understand the rural economies are very dependent on forest industries, loggers, and timber, and they rely on that for much of their economy. But even in Londonderry, one of our larger businesses is Molten, which has a significant stake in the forest equipment. It's a statewide issue all the way around. So I appreciate your consideration of HB 1005. Hope you support the necessity of our commission, and I would ask questions be deferred to the much more expert people behind me on the intricacies of what this could do. Thank you very much.
Thank you, Representative. So next up, Representative Ranzullo, please. Is he here? I'm not speaking. I'm sorry. Okay, so Representative Murner is signed up in support, and he hasn't checked either box. Are you here, Troy? No? All right. And we'll go down to Representative Vos, who's not speaking but in support. Jason Stock, New Hampshire Timberland Association. I would ask you to remember that Polonius was known for brevity is the soul of wit.
What are you saying? All right, I will be brief and I can because you've all heard about low-grade wood markets. Right. Senate Bill 271. You guys get it. I'm passing out for the record. Jason Stock, New Hampshire Timberland Owners Association. We represent landowners in the forest products industry. You folks understand, without markets for all quality and species of wood, the ability to do sustainable forestry, manage mill waste from our sawmills, and then also supporting the logging infrastructure that supplies all of the logs to the sawmills. Without those markets, that becomes very tenuous. House Bill 1005 answers a question that Senator Gray asked, and that was, what's next? You come to us with biomass bills, what's next? this is what's next. And what this bill is aiming to do is set up this commission to look at emerging markets and kind of what's out there on the horizon. So that's really the crux of this. I passed out documents, 2 documents to you that just, you've seen those before on Senate Bill 271. I just gave you the executive summary on the forest industry contribution. New Hampshire, we continue to grow more trees than we harvest. For every cord of wood harvested, there's 1.9, on average, 1.9 cords of wood growing. So wood supply is not an issue. I've had people ask me, well, what if we set up a bio-oil or biofuels facility? Would there be enough wood for that? No question, there is. And so you'll find that on the economic contribution, page 5, paragraphs 3. Paragraph 4 gives a perspective on the forest products industry, $1.6 billion industry. We're a big part of the state's economy. Why we don't get noticed many times is because all our work happens in the woods. We don't have large fancy factories along the interstate. The other document, which I've also provided, was an analysis we did back in November 2020. This was actually at the request of Senator Bradley to kind of explain what's the fallout. We've lost a bunch of power plants. Burgess is kind of on the hairy edge. What's the fallout? What are you seeing in the woods and within the industry? And so this explains it. And in the short version is that since 2019, the total low-grade market for low-grade timber has dropped 2 million green tons. That's region-wide. New Hampshire represents about 1.2 million green tons. Kind of put that in perspective. If you look at annual intent to cut timber tax data, annually, New Hampshire harvests about 2.5 million tons, all species, all products. That's firewood, that's veneer logs, saw logs. So this is a big issue. You get it. I know you do. You've heard me many times over. And in the interest of being brief, I will conclude my testimony. I really hope that you will look favorably on this. This is a commission. I know you get hit with a lot of commissions. This is one that really drives at the heart and soul of the forest products industry and at timberland owners and ownership in sustainable forestry and all the things that come with that, clean air, clean water, and wildlife. And with that, I'll conclude my testimony. I'd be happy to try and answer any questions.
Any questions? Members of the committee.
Okay, thank you.
Thank you for your brevity, Jason. Yeah. So next up, we would have Rob Johnson, Farm Bureau. Is he here?
He's here. I didn't know he was speaking. I can get him.
He's not. My bad. And we have Kelly Buchanan from Clean Energy New Hampshire, not speaking but in support. Marty Mobley, Fish and Game, in support, not speaking. Jean Harrington, Biotechnology Innovation Organization, and speaking in support. Welcome.
Thank you. Good morning, Vice Chairman Gaida, members of the Energy and Natural Resource Committee. My name is Gene Harrington, and I'm the Director of State Government Affairs for Agriculture and Environment for the Biotechnology Innovation Organization. I appreciate the opportunity to testify on behalf of BIO in support of House Bill 1005. BIO is the world's largest trade organization representing biotechnology issues. Our members use biotechnology at all stages of research and product development to further innovation of a variety of economic sectors, including agriculture, environment, and healthcare. New Hampshire's biotechnology industry is comprised of 413 entities employing 6,286 people with an average salary of about $90,000. Enactment of House Bill 1005 could help bolster those numbers. We applaud Representative Thomas and other bill sponsors for introducing House Bill 1005 and are especially grateful that the measure recognizes the important role biotechnology can play in helping revitalize New Hampshire's forest product sector. Wood chips, sawdust, and other woody biomass can be converted to biofuels and renewable chemicals, which are used to replace petroleum to make containers, packaging, rubber, and various consumer and industrial products. The clothes we wear can even be woven from fabric derived from wood. In 2017, approximately 13% of all petroleum products were used to produce chemicals for consumer, commercial, and industrial products. By replacing those petrochemicals with renewable chemicals sourced from sustainably harvested forests, New Hampshire can drastically reduce greenhouse gas emissions and create high-paying green manufacturing jobs. Underscoring the promise of the technology of converting wood chips and sawdust to biofuels and renewable chemicals, the U.S. Department of Energy last September awarded a Dartmouth professor a $1.2 million three-year grant to fund research into the use of biomass to produce next-generation fuels and chemicals. In recent years, Maine, Maryland, Kentucky, Minnesota, Iowa, and Nebraska have all passed laws promoting renewable chemical production. In March of 2020, Maine enacted renewable chemical production legislation specifically to boost the state's slumping forest product sector. For these reasons outlined, BIO respectfully urges the committee to vote House Bill 1005 as passed by the House out of committee with an auto-pass recommendation. Thank you.
Thank you for your testimony. Are there any questions? Senator Waters?
Yeah, thank you, Mr. Chair, and thank you for being here. And I'm really fascinated by all the new products that are coming forward. It's really interesting. And, as far as this commission goes, you note that it lasts until 2023. But given the Maine law, I would hope that I guess as a question, you'd be able to suggest to us perhaps in the fall when we have our filing period some legislation that might work for New Hampshire related to the Maine law that passed.
Sure, absolutely. Obviously we want to see what comes out of the commission, but we're happy to share the Maine law that passed and the laws from the other states. I'm not here to suggest that those laws work for New Hampshire. They're all very state specific. Some of those laws were more focused on utilizing corn in the corn-based states. Obviously, Maine's law was focused on helping its forest product sector. So we're certainly happy to share those laws and see what the commission decides. But we'd love to be part of the discussion.
Thank you so much.
Yes.
Further questions? Can you state with any knowledge whether or not any of these other states have been able to apply ARPA funds towards research and development or actual manufacturing of these chemical products, these new wood-based chemicals, biochemicals, if you will?
I don't know off the top of my head if they've used ARPA funds specifically to do that.
That would be really helpful.
I can look into that, but I don't know the answer off the top of my head.
Thank you. Further questions? We hope. Yeah. Okay, thank you very much.
Thank you very much.
Jody Grimblis. Welcome back.
Thank you. I'll be brief. And just speaking with Jason, the answer to your question is yes, Maine has used ARPA funds.
Okay.
So he'll be able to speak to that. For the record, my name is Jody Grimblis, and I'm here representing Bridgewater Power Company, a biomass plant that's in the Ashland, Bridgewater area. We're in support of House Bill 1005. Mr. O'Leary, who many of you have seen before, was not able to attend today, so I have a letter in his for the committee in his support. Basically, two reasons to keep the commission and the discussions going. Obviously, as all you know, we have not been able to connect the political dots to find solutions to this issue in this industry. We're seeing the aftermath and the effects of it, and we want to keep working. And we think this kind of structure is the best to do. Also, it's a signal. It's a signal to other areas around New England that New Hampshire does support the industry. We do want to work on leveraging our existing infrastructure and trying to better our forest products industry, because what I hear sometimes on the streets is if there's private investment being looked at in this industry, they'll go to Maine because Maine's more supportive. We need to show that New Hampshire supports it as well, and we think this commission is the way to do it. So there is a spot on the commission for someone that has biomass plant experience, and Mr. O'Leary is ready to roll up his sleeves if he's and ready to volunteer if you need. So thank you.
Thank you. Any questions for Ms. Grimblis? Hearing none, thanks very much. And that concludes the list. Is there anyone here who hasn't spoken? Welcome again. You bet.
Thank you, Mr. Chairman. I will be brief. I'm Matt Leahy. I'm the Public Policy Director for the Society for the Protection of New Hampshire Forests. We support this legislation. We think it's very important, and really for a very basic reason. About over 70% of the forested areas in our state are privately owned, by private landowners. And we just think it's very important, to give them other options to consider down the road to help them, manage, harvest their forest, generate revenue, and essentially keep those working forests as working forests in our state. So again, thank you, and we appreciate your support. But I'll take any questions.
Thank you, Matt. Any questions? Hearing none. Thanks again. Patrick Hackley from our Division of Forests and Lands. Welcome, Pat. Speaking as one might expect in support.
Yes. Yep. Great. Good morning, Vice Chairman Gaida, members of the committee. My name is Patrick Hackley, and I'm the State Forester and Director for the Division of Forests and Lands. Here's some copies of the testimony. I'll be brief. I won't read my whole letter, but as you know, as a State Forester, we couldn't be more supportive of this bill, HB 1005. It really comes at an excellent time. You've heard all the statistics from Director Stock from the New Hampshire Timberland Owners. You've heard from our other conservation colleagues out there in New Hampshire, and certainly leaders in the forest industry. It's a $2.8 billion industry annually, and the forest industry is an integral part of maintaining our forested landscape. And as Matt just mentioned earlier, having diverse wood markets, low-grade, high-grade sawmill, sawlog markets, it's these markets that allow landowners to derive a revenue stream from their land. And anything that we can help landowners keep their forests in forests rather than converting to other land uses is something we should be supporting. And as you all know, a thriving forest products industry really serves to underpin this state's recreation and tourism economy. And again, as other knowledgeable speakers have mentioned, New Hampshire is 70% privately owned. So private landowners are really important to our state in so many ways. And so this commission needs to take a hard look at economic hurdles, regulatory barriers, all the issues regarding labor availability, and certainly, as the title mentions, emerging wood markets. There's a lot of good technology that's going on out there. Our friends in the main industry are way ahead of us in terms of funding those efforts. They get it, we get it, but the funding and the impetus, the political will just seems to be flagging a bit here. And so we hope that this commission will help jumpstart that and give the shot in the arm that this forest industry really needs and deserves, again, because it's related to the health and success of our entire economy. So with that, I'll just wrap my comments.
Questions from members of the committee? Patrick, I have a quick one that is not, I want you to do the most condensed answer you can. What happens if we don't find a use for this low-grade timber? Back it up.
Yeah, well, landowners' options to manage their forests are limited, especially since about 70% of most of our hardwood forests in New Hampshire are considered low-grade. Those are the trees that have deformities, they're crooked, they take up space in the forest, and if you can't sell that wood, I mean, there's always going to be firewood markets, and we do have the remnants of a biomass industry still here, but it's again, that's flagging and waning, we know that, for various reasons. So when landowners don't have an option to harvest that timber, Senator Gaida, that low-grade timber, it stays in the woods. There are actually federal programs that do provide some funding for what we call timber stand improvement. And that allows a logger to get paid to cut low-grade wood, but they cut it and leave it on the ground. There's no place to ship it because they can't sell it. So, I mean, there are ecological benefits to leaving fiber in the woods. We all know that, and foresters and landowners are sensitive to that. But really, the best forestry is when you can harvest trees from across the quality spectrum. So, it's just that hopefully that captures the answer you're looking for.
Okay, thank you.
All right, you're welcome. Thank you.
That concludes the testimony. Anyone here who hasn't spoken wishes to for a first time or has spoken and wishes to speak for a second? Hearing none? We'll close the hearing on House Bill 1005, and we will open the hearing on House Bill 1052 relative to the number of rounds of ammunition allowed for hunting regardless of firearm capacity. And I'm not sure, prime sponsor, Representative Spillane. Welcome.
Thank you, Mr. Chair and members of the committee. Senators, I bring forward HB 1052 actually at the request of the Fish and Game Department. If you remember, last year we passed a lever action bill that I had put in that allowed for the use of lever action in certain handgun calibers. At the time, we had already gotten as far as the Senate process when one of the Fish and Game officers contacted me and said, you know, we've always had this confusion among hunters as to whether the magazine had to be able to hold no more than 5 rounds or whether it was just meaning 5 rounds in the weapon. And I mean, I'm guilty of it myself. I always thought I needed a magazine of 5 rounds or less when I was hunting. But it turns out that Fish and Game has always had a policy of it's how many rounds are loaded in the gun, not the size of the magazine. And I told them I don't want to amend the bill because it's nice and clean and it's going very well, but I'll put in a bill specifically for you next term, and we can clean that up. So what you see before you is cleanup of the language, and Fish and Game also requested that we make it 6 rounds instead of 5, so that a revolver that's being used is the same number of rounds as the rifle. And so that's what it is. It just takes out the discussion of magazine or clip, and it just says that a semi-automatic rifle may be used provided it is loaded with no more than 6 rounds of ammunition at any time, clean, and gets rid of the confusion for Fish and Game.
Okay, any questions? Please. He's not listed, but I'm sure that he will.
So it sounds like that there really isn't a concern about being able to tell because it's a larger magazine. I mean, in terms of enforcement, it's just I kind of wondered about, you know, you can see the size of the magazine right away. It's the size of the magazine, but if it's a larger magazine,
right,
you gotta go and actually, you know.
Well, and if you think about, Senator, thank you for your question. Part of the confusion from my end that I always thought it had to be a 5-round magazine and no more was because I also did duck hunting, and I knew that you had to put a plug in your tube to have no more than 3 rounds shotgun shells in there. And so that's where I think some of the confusion came about, but I've been told by Fish and Game that they've always followed a policy of it can be a 10-round magazine or 20-round magazine, doesn't matter as long as the gun only has 5 rounds.
Okay, so you'd mentioned the number 6 because of revolvers.
That's what they asked for.
That's not mentioned in, revolvers aren't mentioned.
No, they just part of the handgun issue. It doesn't matter what type of handgun, they just want 6 to be consistent between handguns and rifles. And they said, let's make it 6 everywhere. So I believe there's another section, so maybe the colonel could answer this, but I believe there's another section that talks about 6 rounds somewhere, but we made this 6 rounds to be consistent.
All right. Any further questions? Thank you very much. Can you answer that, Colonel, please?
Yes, I can. Thank you, Senator. So originally, the law read that you can only have, the restriction was 5 rounds. I think Fish and Game didn't want people to go out and purchase additional equipment. If they had a 30-round magazine, we didn't have a problem with that as long as they were only using 5 when they're hunting deer.
My question is specifically on, does this, as written, cover the 6 rounds?
Yes, so when Representative Splane's bill went through, it included revolvers, which allowed for a full capacity of 6. And so we didn't catch it in time as it went through. So when that bill passed, half of the state or towns in the state could have 6, the rest of the state could have 5. We were concerned that people get confused with that. We were confused with it. We wanted to make a universal, easy for everyone to understand language, and that's why this bill came through. Representative Splane agreed to do that, and we decided to go with a 6-round statewide just to make it simpler.
And so what I'm saying is the semi-automatic rifle is what's listed. It doesn't list revolver.
It does not, no.
It doesn't have to.
No, it does not have to. No, sir. No.
Thank you very much.
No,
Further
thank you.
questions?
Thank you very much.
Thank you, sir. All right. No one else has signed up to speak. Does anyone wish to speak a first time or speak a second time that has already spoken? All in one breath. All right, then we'll close the hearing on House Bill 1052. And is there any interest in executing anything? Okay. Okay, so Senator Waters and Senator Gray move and second on executive. All in favor? Aye. Any opposed? Okay.
House Bill 1052 pass.
Second. Any discussion? Hearing none. All in favor, signify by saying aye.
Aye.
Any opposed? Okay, carries. I'll take that out. Okay, and any other bills of interest? Yeah. Okay, there's a motion about to pass on House Bill 1005,
Second.
seconded by Senator Perkins Coca. Discussion. Hearing none? All in favor?
One piece of discussion, thank the author, saved Josh a trip up to Hashtag.
Their names, yes.
All right.
They're there,
Yeah,
right.
that's what I'm saying.
Yeah.
I was commending the author.
Yeah, that's right.
I checked.
All right, further discussion. Hearing none, all in favor, signify by saying aye.
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 Any opposed? All right, just gonna take that out.
I can take it out.
Senator Perkins Cook will take that. We did that, yeah. I'm good with it.
All right.
Move to come out of exec.
Second.
Okay, Waters and Gray, all in favor, signify by saying aye.
Aye.
Any opposed? No further business coming before the committee. We are adjourned.
Adjourned.
Turn off your mics.
Good job, Mr. Chair.
Yeah. We got an awful lot of bills still left on this master sheet, though.